Understanding the rules of ex-parte communication. If you are involved in or interested in a proceeding before the California Public Utilities Commission, better known as the CPUC, it's important to understand and follow the rules around ex-parte communications. These rules are governed by the CPUC's Rules of Practice and Procedure, and failure to comply could lead to serious consequences, including fines and other penalties. Let's take a moment to break down what ex-parte communications are and how you can stay compliant. Ex-parte communications refer to any private discussions between an interested party and a decision-maker about the substance of a proceeding, discussions that take place outside of a public hearing, workshop, or other public forum. The CPUC defines interested parties as being agents, employees, attorneys, credit rating agencies, investment advisors, CPUC advocacy staff, or representatives of civic, environmental, neighborhood, business, labor, trade, or similar organizations who intend to influence decision-makers on a matter before the CPUC. A decision-maker could be a CPUC commissioner, a commissioner's advisor, the assigned administrative law judge, the assistant chief administrative law judges, or the chief administrative law judge. Now that we know who's involved, let's explore how ex-parte rules apply to different types of proceedings. There are 4 categories: adjudicatory, rate-setting, quasi-legislative, and catastrophic wildfire. Ex-parte communication is banned in adjudicatory proceedings. If ex-parte contact happens, then it must be reported. Ex-parte communication is allowed in quasi-legislative proceedings without any restrictions. However, the rules are much more complex. For these 2 categories, ex-parte communication is permitted, but a notice must be filed with the CPUC 3 days before and 3 days after the meeting. Ex-parte meetings are not allowed during the week of a CPUC voting meeting. In addition to the ex-parte notices, written communications must be provided to the CPUC on the same day, and the service list must be copied. There are some exceptions. For example, a decision-maker's presentation or conversation during a question and answer session where an interested person is present is not ex-parte communication. The same is also true if an interested person is presenting and participating in a question and answer session where a decision-maker is present. We hope this video has helped clarify the rules around ex-parte communications. For more detailed information, visit www.cpuc.ca.gov and search for Transparency and Reporting.